board discussed expanding the overlay at the last meeting, it was mentioned that more facts were needed. You did have the facts from the Wind Advisory Board, and as mentioned, your law states that you would go to the Wind Advisory Board for the overlay. The developer would like you to believe that you do not have a current wind overlay. You as a town board know that is not true. The original wind overlay has been on the website with the law. The town board did vote on, did pass the original overlay when they passed the current law that is on the books. To no fault of your own, only the wind law was filed with New York State. This is a loophole, a mistake that Iberdrola has found. This company is very good at finding procedural mistakes. They look at these small town boards, most of you who have full-time jobs doing other things than the board, and they look for what mistakes you're going to make. They are taking advantage of you. In the PIP, which was filed by the company in May of 2016, they stated the project was going to be made up of mostly agricultural land. 1 year later, May 2017, the PSS states that the project will be made up of 79% forested lands. So what's going to happen to this forested land? Well, their PSS states that it takes 125,600 feet, an area, that much meaning 2.88 acres per turbine. 2.88 acres, almost 3 acres of land is going to have to be destroyed just to put in one turbine. So each turbine, you're destroying 3 acres of land for the turbine itself. That does not include widening the roads to get the turbine parts to the location. Does not include access roads. It does not include the land that will be destroyed for the transmission lines. That is just per turbine. As you know, the land south of 72 is heavily forested. Includes a lot of state land. So by allowing turbines south of 72, you are creating deforestation. Habitat will be destroyed. The forest will be forever destroyed. There are also several wetlands within the project area, many of which are south of 72. The developer has stated that there are 263 wetland communities that take up 888 acres. Much again of this is south of 72. So they've also stated that they will have to convert some of the wetlands. So in other words, they're going to destroy, get rid of completely, forever, several of our wetlands, much of that being south of 72 if you allow the turbines to go there.
Thank you.
I'm one of the leaseholders of West Bloomfield, south of 72. Gilbert Madrid. I am a leaseholder. I am in favor of the wind overlay for 72. That being said, can I take it or leave it? Yes. What this board needs to do is listen to your majority of your taxpayers. Not this group, not this group. You need to do some research. You need to talk to all your constituents. Are they pro, are they con? And do what you were voted to do and support your constituents and vote what they wish for you to do. That's your job. That's what you got to do.
Thank you.
Wait, did he say he was a non-resident? I didn't
I
get
am.
that.
Yes.
Okay. So you're not going to live where this is going to be?
I said there you
Okay,
go.
sorry. Stating the obvious.
Yes, sir.
I'm Rick Huber. I live down 72 here. I did 26 years in the military. I did plenty of years in the Hopkinton Fire Department. And I own my land. I don't have a lot, but where I've been in the military, I was on a flight line, noise all the time. I'm not dumb. Actually, I'm pretty smart. I've got an eyesore in my backyard, a Verizon tower. It don't bother me. It's just there. Jets go by, no big deal. But everybody who wants to sit here and complain about everybody else, what they want, because they own their land, it's their land. If they want something, why can't they have it?
Because it
If
affects
I
other
could
people.
have one myself, I would. I don't have enough money. I don't have a job. I don't work. I'm a disabled vet. And what money I do get survives my family with help here from the community. And I have no qualms against this gentleman here. He bought the chunk of land across from me when I bought the house up the road. It was no good to me. It helped him with his farmland. I'm not going to make a lot of hassles with people. I'm not that type of person, and people have to get along. If it comes, it comes. If it don't, it don't. But it's going to happen eventually, whether some people are going to like it or not. But I have no objections at all to what it is. Thank you.
Thank you. And thank you for your service.
Thank you.
David Slater, out of Nickelville. I'm just thinking forward after this meeting and as we move this whole progression towards Article 10, because of the reality that's what's going to make the final decisions on what happens to this project. I just want to keep in mind just some things that, one, I don't know offhand, and I don't think you're answering questions, if Parishville's revised wind law was ever ratified or not. If it was, then we have to be careful that we also kind of coincide with the same type of letter of law. Otherwise, we're going to have probably conflicts of interest, which I'm sure, and I am kind of mostly neutral about this project, but I'm sure Avangrid's smart enough that they're going to be able to leverage and take advantage of that if we have conflicts of interest between the two communities, because the towers are in both those communities. So I would like to also point out that once the wind law is ratified, no matter what the setbacks, I think, and this I believe is in both versions of the wind law for Parishville and Hopkinton, is that there's supposed to be an engineering study done then to follow up on this to get exact site dimensions of the radii around whatever setback whatever is decided upon by both communities in full detail by an engineering firm. And I think that's going to be highly critical that that is released to the public as soon as feasibly possible, whoever pays for that, because I think that's really going to give us a very, very good picture that all of us will be able to follow, whether you're a leaseholder, a good faith leaseholder, a good neighbor leaseholder, excuse me, or a non-participating leaseholder, of exactly where these setback radii are going to affect, whether it's going to be on your neighbor's property and they might have a tower, or whether it's on all the adjacent properties and there are no towers except one on the corner, or if it's going to affect Catherineville State Forest, or no matter where it's going to affect. I think we really need to have that kind of hard fact data in order to really drive our decisions again, especially as we move closer and closer to Article 10. Because I don't know how many of you read that really, really onerous, long the comments from Avangrid based off the PSS comments, but most of their comments really reference Article 10 and the application phase. They're not answering a lot of the questions in the pre-application phase because they don't have to. By law, they only need to follow whatever the Article 10 process lays out for its 6-step process. So I just want to make sure everybody keeps the big picture and the final end game in front of their face.
Thank you.